It is great to have you back here at Coin Lady channel. Dear everyone, is the Remedy face ready for the Torres decision? The most famous cryptocurrency exchange, Coinbase, has asked the court for permission to file an interlocutory appeal with the Second Circuit. Metal Lawman, an XRP advocate, has spoken out about the development, which has started conversations in the market. The lawyer recently shared Coinbase's compelling arguments in an AIX post. In addition, he highlighted how this case has the potential to speedily settle crucial issues concerning the power of SEC in relation to digital assets. The XRP attorney praises Currencybase's persuasive arguments. The Metal Lawman commended Coinbase's legal team for the compelling case they put forward in favor of an interlocutory appeal. The question of whether exchange-traded digital assets constitute securities will unavoidably be brought before the Second Circuit Court of Appeals, he noted. However, whether the issue will manifest and when it will manifest are the two variables that may be considered uncertain. He further mentioned that interlocutory appeals are rarely approved. But, given the centrality of the problem to the persuasive reasons presented, the Coinbase case seems to be especially appropriate for rapid transfer to the Second Circuit Court of Appeals. In addition, the Metal image emphasizes how fundamentally important the issue is to the entire Bitcoin industry. To set the stage and highlight the gravity of their request, Coinbase Chief Legal Officer, Paul Grewal, recently made an announcement. He elaborated by saying that they are trying to figure out if the SEC can control digital asset transactions, because the number of investment contracts that don't have a legal basis is growing. Additionally highlighted the reality that the SEC itself recognized the significance of this issue in the Ripple case. The SEC took note of the issue's industry-wide importance and the fact that there were growing considerable grounds for differing perspectives. It should be mentioned that Coinbase has consistently sought clarification from the SEC. Furthermore, it was noted that throughout this period, the company sincerely reached out to the SEC in an effort to establish a regulatory framework that would allow for practical advancements in cryptocurrency within the US. However, as per Google's account, the Securities and Exchange Commission's (SEC) lawsuits, position shifts, and efforts to clarify its request for an interlocutory appeal over cryptocurrency regulation and its future were met with pushback. By standing up to what it sees as the SEC's overreach, Coinbase shows its commitment to providing transparency to the Bitcoin industry. In addition, Grewal emphasized that this appeal is crucial for the entire cryptocurrency industry, the 52 million US residents who own cryptocurrencies, and Coinbase in particular. He went on to say that the need for transparent regulations has been recognized by the House of Representatives, and that Coinbase is seeking a same degree of openness from the courts. What makes Grewal's statement stand out is his assurance that Coinbase will see this issue through to its end at its own pace. Meanwhile, he believes that in order for the digital asset area to move forward, there needs to be clear and practical crypto regulation, and that Coinbase decisions reflect the sector-wide demand for regulatory transparency and fairness. Considering that Ethereum was just classified as a commodity by the US Securities and Exchange Commission. Not only has the connection between Coinbase and XRP been talked about recently, but the XRP attorney had also expected Coinbase to file a request for rehearing at the same time. This is timed to coincide with the announcement made by the leading cryptocurrency exchange about relisting the XRP token for New York users on their platform. The US Securities and Exchange Commission has also been informed. As can be seen in response to the SEC's lawsuit concerning XRP, Ripple Labs has presented their arguments regarding remedies. During the remedies phase, the plaintiff, defendant, and any third parties waiting for Judge Torres's final verdict, anticipated after the decision is made regarding the motion to seal, were at odds over the decision to conceal certain information about Ripple's financial results and the subsequent sales of XRP to institutional investors. Legal experts specializing in the XRP case predict that a decision on the cryptocurrency bill and the lawsuit against Ripple, the Financial Innovation and Technology for the 21st Century Act, might be handed down as early as the third quarter of 2020. The United States House of Representatives had a vote on 21. The first step in creating a regulatory framework for the issuance and trade of digital assets is this legislation. It will also affect Coinbase, Finance, and other businesses because it will specify which federal agencies have authority over Bitcoin in the US, the Commodity Futures Trading Commission, FFC, and the Securities and Exchange Commission. Legislators have acknowledged that Judge Torres' short opinion from July 2023 significantly influenced the cryptocurrency bill's design, which bodes well for its passage into law. What this means is that the XRP litigation could be impacted by this crypto law. XRP is not a security in and of itself, according to Judge Torres' decision, and assertions that an investment contract asset is a security are not taken into consideration by Bill Crypt, which is a part of cryptocurrency law. No investment contract's sale or transfer of a digital asset, or the mere intention of such a sale or transfer, can be considered a security. The paper claims that XRP's potential lack of decentralization was the subject of rumors. A lawyer by the name of Bill Morgan chimed in, arguing that the law does not apply to earlier cases. Just on its own, XRP is not considered a security by the court. However, according to the Securities and Exchange Commission, the company is merely required to pay civil fines not exceeding $10 million. The SEC, however, is requesting a final judgment and a $2 billion penalties in total. The real cost would be far lower, but courts have never accepted the amount that was initially asked by a side. Indeed, this is spot on. In my opinion, Ripple's existing OTL sales agreements presuppose the possibility of a permanent injunction being granted in the most extreme case scenario. In this method, XRP and SLD are not utilized. In the event that it passes, transactions will likely also be able to sidestep FIT21. The local infrastructure vendor, Endless Block, started helping with the validation of XRPL transactions in May of this year. Just as another round of speculation about XRP's potential US acceptance was heating up, the news broke. The video ends there. As always, I'd appreciate it if you could subscribe and leave a comment with your opinions. Coming up shortly, farewell.